Okay, I think we are now starting. First of all, let me introduce myself. My name is Antoni ABAT, and I am the scientific coordinator of this project, EXPRESS. Before we start, let me inform you that we are recording, so if you don't have any query or any problem with this, allow us to record, because we're going to use it for our internal purposes and to enrich our project.
Antoni, I think it's not working properly. Antoni?
No, they appear to have technical problems.
Yeah, I think so.
Okay, let's give him a couple of minutes. In the meantime, we can give time for people to join in. For those of you joining right now, our project coordinator, who is going to give the introduction to the winter school, is having technical problems. So let's wait for 1 minute to see if he can join back.
Hello again. I mean, I'm now with my mobile phone, so I hope that this time will work. Again, hello, thank you very much. My name is Antoni ABAT, and I'm the scientific coordinator of this project. Welcome to the winter school. Today we're going to be, as I said before, we are recording this meeting, so it's basically for our purposes. And today we're going to be talking about the theoretical framework. We're going to introduce a little bit the project. We are honored to have our colleagues Jakob von HOLDERSTEIN, HOLTERMANN, and Professor Giuseppe MARTINICO, and also Dr. Jorge PIñERA and myself. So we will introduce a little bit our agenda of today, which is, as I said, these welcome remarks. Has been a little bit disruptive because of the connection. We will then explain the theoretical framework, and what we expect in this winter school is basically to introduce, to expose what's our project about, and to invite you to participate with questions, answers, and also we are also planning some interaction with you guys if you want to get involved in our project. So I will namaste, because I wanted to also to greet in because we have a lot of Indian scholars and professors, so you are very, very welcome. I will try to also link, because of you, some of our projects, ideas and insights with the Indian social contract. And I hope that, this whole 3-day session are very beneficial, and you have fun, which is at the end of the day, the basic goal. I introduce now my colleague Jorge PIñERA, who is doing a PhD and who is involved in our project, and he will explain a little bit what is the winter school and how this is structured. Thank you very much again.
Well, good morning, everyone. First of all, thank you all the students and all the project researchers for attending this Express Winter School. So just before I explain a little bit on what the winter school is, as Antoni was saying before, the project Express has, let's say, 3 objectives. On the one hand, creating or crafting a new social contract. The second one is protecting it from different disruptive elements. And finally, and probably the most important objective we have, is to promote the citizens' engagement and participation in the discussions. So, as one of the target groups of our project are students and young people, we have mainly 2 activities directly for you. On the one hand, this winter school, and on the other hand, the young scholar context that will be celebrated in the month of May, and you as participants in this winter school will have the possibility of participating, and of course sending your abstract that will later be selected to be presented in May. So regarding the winter school, as Antoni was already mentioning, it has 2 main objectives. On the one hand, disseminating both the project and the research we are conducting within the framework of the project. That, on the other hand, and as I said before, promoting this deliberation and somehow gathering feedback from young people, so as your voice is represented in the social contract. So the idea is that each day you have 3 sessions with different researchers of our project. Today, as Antoni was mentioning, we both will be presenting the theoretical framework of the project, and then Jakob von HOLDERSTEIN and Giuseppe MARTINICO will be presenting 2 of the disruptive elements we are tackling in the project. On the one hand, insecurity, and then Giuseppe will be talking about populism. So each of the sessions will be lasting for 30-35 minutes, and the idea is that you will have a short presentation of the research we are conducting, and then some questions in order to encourage the debate and somehow gather feedback. So for us, it is really important that you all participate and somehow that we gather feedback, since one of the main ideas of this winter school is that the young people's voice is represented both in our research and in the social contract draft we are preparing, and that will be presented now by Antoni. So I think this is all by my side. I will let the floor to Antoni ABAT, and before, just let me wish you 3 productive days and a fruitful discussion with the rest of the colleagues and EXPRESS² researchers. So thank you very much.
Okay, so we are now swifting and we move our mobile phone. So as as Jorge was mentioning, we are now explaining a little bit with which is our research. We in the Universitat Autònoma, myself and Jorge, we've been conducting what it was with of course the rest of the colleagues, the basic theoretical framework of the European Union social contract. In this sense, the first thing that we were conducting was trying to envision how do we understand which were the basic sources from a philosophical but also political scientist and legal aspects on the social contract. The idea, of course, is to establish a basic mapping of authors and doctrines from the very origins of the social contract till the last doctrines and theories, again, from also philosophical or legal perspectives. But the first question that we were facing, the first idea that we had in mind was that it was clear that we were not the ones called to draft a European social contract, meaning that our project is not it doesn't aim to be an elitist project. I mean, we are not the ones deciding the content from a material perspective about what the EU social contract is, especially because we are encouraging democratic deliberation and participation, and we want to then, once we have a draft, a very first draft, to engage the discussion. So realistic, from a very realistic perspective, the main goal that we have is to engage these kind of discussions, is to engage people. We use the concept of inhabitant and not citizen in order to try to achieve a more participation and not only limited to the concept of citizen. I will go later on up on this topic, because I think this is also key, and it shows which is our main vision and which is our main objective with the whole social contract. But at the end of the day, the main idea, as Charles Mills proposed, is to engage, to discuss on the social contract, not only as an instrument, but about the topics that we address in. And again, we are really conscious that we are not the ones to be drafting the content, the material content of social contract. So once we knew what we wanted to do, and the first thing that we addressed was to establish this theoretical framework of a social contract. The discussions were, of course, let's say, conditioned by the main names of social contract, and our first draft, which is already done, was affected by this kind of theoretical authors. We start with some Hobbesian aspects. We go to Hobbes clearly in the influences of Hobbes. We work with the authors of the so-called Golden Era, meaning Hobbes, Rousseau, and also we have some Kantian influences when we are dealing and attaching some of the, let's say, ethical or meta-ethical principles of the social contract. So we analyze Hobbes, we work with Rousseau. We also include in the terms of some terms of freedom, which is addressed by Locke. And then we make a jump till a more contemporary and modern theories, very, let's say, influenced by John Rawls' theory of the justice and political liberalism. And we end with criticisms on the social contract based on, let's say, feminist theorists like Carol Pateman, also racial criticisms like Charles Mills. So the draft that we were talking, the frame that we were establishing in order to how do we conceive from a theoretical perspective and from a philosophical perspective, the EU, the potential EU social contract, let's say, was anchored to these main authors. In the different papers and policies that we have already made, we are addressing these elements of these different authors. in order to as I said, establish this frame and then to produce the very first draft. Some of the let me point, at least because we don't have a lot of time, and what I really want to do is to listen to you about your ideas and your comments. Some of the issues that we were, let's say, introducing was that we were facing, and we were taking up on different aspects of these different authors, like a fishing of the different theories. It's, as I mentioned before, that we address to the concept of inhabitants. The concept of inhabitants that then, when we drafted in the as a version, we also use a kind of concept of similar to residents. If someone addresses and analyzes in this golden era of authors, especially in Locke, but also Rousseau, so that normally the social contract is made by citizens. But in our case, because the specific casuistry of this instrument, and because we want to, as I said, to engage with discussions with the population in a broader sense, we use the concept of inhabitant. Inhabitant as so we are somehow changing the one of the authors of this social contract, because, as I said, citizens in their parcel of sovereignty, as Hobbes will say, provide this parcel of their sovereignty to the Leviathan in the Hobbesian sense, or also the citizens in Rousseau to the sovereign state, in order to establish this metaphorical contract. So we provide this parcel of sovereignty, and you provide us, in the case of basically Hobbes, peace, security, and well-being. But we aim to base it on the failed constitutional experience of Iceland, but also on the comments of the Portuguese constitution that was amended lately in 2005, I believe, which is addressed to the residents too. We aim that to provide voice and to participate with residents in the European Union, that they do not need to have necessarily the concept of the consideration of citizenship. This, I think, is something innovative that we're trying to engage with more people who are living with us, and to be more inclusive in the sense of content, because our neighbors have some kind of residency in the European Union to participate, and they will be affected by the rights and obligations that are then established, and views and proposals that they are established by themselves and by ourselves in the social contract. Other aspects that I would like to remark is that, of course, the social contract, as I mentioned before, and if one analyzes the whole evolution of the European Union from the very origin, it can see some Hobbesian traits, let's say. The European Union was born after the Second World War, as you all know, and basically the idea was to provide well-being, peace and security, which is these are very Hobbesian terms. And the states were providing parcels of sovereignty progressively politically in order to ratify this social contract. So the way that we envision social contract is, let's say, kind of hybrid, because it's addressed to the inhabitants of the Union. We also aim to participate in institutions, but we consider that the states that were the originary, let's say, participants of the social contract and the origins of the European Union, they need to be taken into account. In this sense, the European social contract is also, it can be considered as a sort of social contract of social contracts. So, because it will be conformed by the social contract which is made in Denmark, by the social contract which is made in Spain, and the social contract in France in the different member states. There are commonalities, there are different aspects that made this EU social contract by their own, let's say, autonomous. But again, we don't want to step in on the member states' own casuistry, particularities, and own social contracts. Another, I think, idea, this is very Kantian, also Rawlsian aspect, but even we can talk about the concept of freedom in Rousseau, is that we are establishing a kind of attachment to the EU fundamental values, which are established in Article 2, and also to the Charter of Fundamental Rights of the European Union. Meaning that we are, as we said, and as I said, our intention is to open the discussion to everybody in the sense of inhabitants or residents in the European Union to participate in the content of what it can be the social contract. But there is a kind of requirement to say it in a more, let's say, popular way. If you want to sit and talk, you need to accept, you need to acknowledge the values, the funding values of the European Union, which are, as I said, established in Article 2, and also in the Charters of Fundamental Rights, meaning that we can discuss about everything, we can discuss about different aspects. We are proposing in the draft already different elements, which are our first, let's say, kickoff for the discussion. But if you want to participate in our discussion in this EU social contract, you need to respect the boundaries, this red line, which is established also from a material perspective on Article 2 and the Charter of Fundamental Rights of the European Union. Of course, you may ask me, well, Antoni, but what happens if, as we are seeing now, if we serve in the European Union, there are different interpretations of these values? Because if you read what the Hungary says or what Poland says, they say that some of the funding values, their own funding values, can enter in collision with what is the funding values nowadays of the of the funding values of the European Union. So, and who are the ones making the interpretation of the funding values? As you may know, and we have Professor HOLTERMANN, which is also a specialist in philosophy of law. This has been, and it's still being, a huge philosophical debate on the concept of the values what happened in Germany after the Second World War, with these discussions of Carl Schmitt and Bokenforde, Hermann Heller, about who is the one making the interpretation, the valid interpretation of what the funding values is. This is something that we want to, or we aim to escape when we are discussing the social contract. And the way that we have been thinking is, maybe it's wrong, but this is also open to the discussion, is that it's not only the content of which is established in the funding, in the Treaty of the European Union and the Charter of Fundamental Rights of the European Union, the concepts and the elements of the funding values of Article 2, but also the commitment that the states, the member states, had when they entered in the European Union. So, as you may know, when one state wants to get in the European Union, he needs to fulfill some criteria, Copenhagen criteria, and other aspects. And one of them is to have in your own, to have your own funding values, which are the ones which are established in Article 2, which are the same, or you have the commitment to have in your own member state. Meaning that now it's not fair to say that nowadays, even though we understand that the values can evolve or even or regrets or a change, they can be mutable. But what it matters in our understanding and from this European perspective is that the Article 2 and the commitment that the states had when they entered the European Union was to respect Article 2 and also to accept the interpretation of Article 2 made by the European institutions. So it's not the Constitutional Court in Spain, or it's not the Supreme Court in Denmark, or the Constitutional Court in Hungary, the ones to make the interpretation of the EU values. You can say, well, but in Hungary, we understand now that the family is blah, 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 which it can enter in collision with some other fundamental values, funding values of the Union. Well, this is a valid argument, but you need to take, you should take into consideration that that was the case also when you enter in the European Union, and therefore you are changing, you are aiming to change the value of these fundamental values. Well, we have other aspects. We have on the social contract. We are trying to discuss some of the criticisms. We are trying to escape of the regional positions in the Rossian sense. We introduce elements on the concept of Charles Mills. When I'm saying that the idea of the end of the day of this express, which is quadrant express, because we want to allow to the people to express themselves for the one hand, and then to the second hand, to have something tangible, social contract that you can read it. That's so this is also affected by some of these basic authors that we will of course have time to discuss. We have already, as I mentioned before, worked on the very first draft, which is here. One of the questions that we had was how to type and which were the models and frames to be used. We were thinking about first a kind of more declaration, public law declaration. Let's think on the Declaration of the Citizen of the Man in Paris as an example, or United Nations Declaration of Human Rights. Then to establish this public, let's say, more public aspirational declaration, public law. But on the other hand, we also wanted to establish more this strict, more efficient pacta sunt servanda from a more jus privatum tribal law with consequences and with the format of a contract. So it was, we were discussing and among ourselves and with other people about this, let's say, antinomia, right? It could be an antinomia, but at the end of the day, it was not this antinomic, because we found and we thought that we can mix it in a kind of, again, an hybrid document. So we have a sort of a very basic preamble, that will be very public law, let's say, sphere, right? Where we are establishing the basic principles of that we are, what we aim, what we are committed with, the rule of law, the values, which we are defining, which they are defined as meta-ethical principles that we, as I said before, they are not disposable, so the people we can discuss, but this is something that you need to respect. Then we go to a non-dispositive part, which is based again, reaffirming on human dignity, freedom and equality, based on democracy, rule of law and respect of human rights. And then we go to this let's say, more, we have some exclusions. With this exclusion is related with, as I said before, the ones who do not adhere to these ethical legal principles of the union, then are excluded to participate in this deliberative experience. And it's not a pejorative sense, but if you want to, let's say, to think about a libertarian European Union, or as or a neo-conservative European Union, and you want to change the values, the founding values of the European Union, it's very perfect. I think it's very legit. You can do that, but this is not probably the instrument that we were thinking and envisioning, right? For the first hand. On the second hand, probably you are thinking about a different European Union, which is related with the last speech in Munich security security meeting, that some people were saying that, well, probably the values have changed. Well, if this is the case, you can do other experiences and experiments and try to change it and change the Article 2, or to have a different idea of European Union, which is not our part. So we are also following this jus privatum contractual form. We established some dispositive part. This is basically what we have thinking that we can discuss, which are honestly very related with what we thought at the very beginning with our disruptive elements, right? Some of the elements of security, populism, and disinformation, how the European Union need to tackle these elements. This is what we are envisioning and proposing, and we aim, as I said, we will discuss. What we aim is to establish kind of effectiveness and less aspirational, or less aspirational perspective. Disinformation. We are also talking about the gender equality, how with already the Communitarian Acquis, the treaties, and the documents, which policies could be include within the European Union in order to, let's say, afford a more gender equality. We are also tackling elements of climate change, trust, digitalization, which are, as I said, health, and then we are introducing other aspects, basically on following Minutius Afik proposals on socioeconomic conditions, also Charles Peel's sphere, education, youth. And finally, aging, yes, this is also minutiae. And finally, we are establishing final clauses on amendment, duration, and termination, the forum, and how to read the contract from an integrity perspective. So this is basically, as I said, the idea to have this draft to discuss. I'm sure that there are a lot of other disruptive elements that we probably will find, that we will probably include in the contract, and to engage this conversation with the people, with you guys now in this winter school, and to engage, to debate. And the idea is ending with policy recommendations. We were even thinking to, once we have a final draft after the 3 years, which is the term duration of the project, to establish a citizen legislative initiative. We will think about this. This is also in order to try to channel all these inputs and that we're having, but this is something that we are now talking about. So if you have already ideas about how to make more efficient, you are more than welcome. And I'm really eager to have your comments and questions. I know it has been a very fast and let's say summary presentation of the contract, which and the theoretical framework. I'm simply mentioning some authors and very basic elements, but I'm really open to follow up with your discussion. So I think we have now 10 minutes, 5 minutes to have 10 minutes to have debate, questions and answers. I don't know who is the one. You, me, myself. So because in the mobile phone I cannot see very well who is talking and who is not talking, right? So I'm open to questions and to open the floor to you guys if you have questions and to open the debate. Again, thank you very much.
There is a raised hand from Alberto Barrio, and I think that all the attendees are able to raise their hands, and I will activate their microphones.
Yes, please do so, Virginia, because otherwise I cannot see it. You know, my connection today is horrible, so I'm with my mobile phone. So, Alberto, ¿cómo estás?
Muy bien, muchísimas gracias, Antoni, por la excelente presentación. Bueno, ya sabes que a mí este proyecto estoy encantada de formar parte de él. Thank you very much for the excellent presentation. I'm really glad for being part of this project. I find this topic fascinating. I was just curious, I'm going to add here as a lawyer, it was just, I understand that this is probably not the purpose of this document and the contract, but I just wanted to know how you thought about mixing this proposal with the issue of EU competencies. Because of course, I fully agree with many of the proposals that you make, but some of them have been already tried, and particularly in the field of social security, where we always face the barrier of, first of all, that the competencies are limited, but also of how difficult the legislative process for approving any of these kind of laws can be. I mean, an example could be, for example, the recent directive on platform work, which even though it seems to be very much approved by most of the countries, it was extremely hard to approve. And this is including the opposition of some countries like Nordic countries. So I was wondering how you consider that, because I see that many of your proposals are very ambitious. So I don't know how you consider it. Thank you very much.
Well, thank you very much, Alberto, for your question. This is one of the key issues that we are now addressing, to be honest. So what we are aiming, what we are targeting as a, let's say, the very first frame will be the ones who the European Union has its own competencies. We are aware that maybe some of the competencies are under dispute. First thing, all the things that the states, we are very reluctant to allow, let's say, an expansive interpretation of some of the questions related with competencies. This is a huge topic. Again, we are not really at this stage. We are not really aiming to enforce the contract as a real contract, but to engage discussions on the contract. That will be the main goal. But following your question, because I think it's very fair, what we are doing now is in our first clauses of the contract, in the disposals of the contract, we're establishing some kind of references saying within the frame of the European Union competencies. And that would be enough. I mean, if we are able to engage some discussion, if the European Union at the end of the day, or European Union institutions, or through the citizen initiative legislative, we can include elements saying that under the competencies that the European Union has, we are reinforcing this social contract social contract, EU social contract, I think that would be more than enough. I mean, another thing is that, of course, we cannot step on the competencies that the states have. So let's say that the ambitions of the social contract is first, as I said, engage in discussion and to debate and include inclusiveness and etc., etc. But on the other hand, is to reaffirm, probably within the competencies of the EU, these policies, these elements that we are targeting in the disposals of the contract. So we are not, we cannot step on the competencies of the states, I think, and we don't want to do so either. But and what we are trying to do is to reaffirm, to establish what the European Union already has. Also, don't forget about the jurisprudence of the European Court of Justice, etc., etc. So the whole communitarian acquis. So I think that will be more than enough. But again, thank you very much. It's a very fair question.
Thank you.
Is there other questions? Virginia, no, I cannot see the questions if someone...
I don't see any hand raised.
Okay, so if I have 2 minutes, let me also think about something, because we have Indian students, as I promised before. So one of the ideas, and I think that would be interesting for you and also for us, from Indian students, is, let's say, to compare. There's not a lot of jurisprudence, there is not a lot of doctrine on the Indian social contract. There is an article by Minush Safik, which was in the Indian newspaper, about this social contract, but this is an issue that has been lately also reproduced. I have 2 chapters in a book, but it's not really, it has not been so far as I know, a very popular topic in India for different reasons. And I think this will be a good path to discuss about how, whether it will be a good topic to discuss how a Indian social contract has been done. Is the EU social, is the social contract theory applicable to non-Western or North countries? Is this a kind of epistemological colonialism or not? Is Modi, for example, changing the Indian social contract? For example, these are topics, and then to be compared with the EU, right? Is the social contract, the Constitution of India, can be considered as a social contract? So these are topics that I believe that can be interesting from a comparative perspective from India to Spain. I think there's a hand, Virginia.
Just a second.
Yes, yes, Professor Anto. Yes, because Hakim Mohit. Yes, there's the hand of Professor Anto. Please, yes. Professor Anto.
Yes, Professor, thank you so much for bringing in Indian perspective as well. That is a very interesting thing to, hear, and that is a very valid question that you put forward, like how the social contract theory is evolving in India. Probably, the constitution by itself, we start with the word "we the people of India," so it's a typical indication of how social contract is being followed in India, theory is being followed in India, and how we have agreed upon certain principles. So I think this is going to be a wonderful discussion on how the principles are changing. Maybe if we see how we had a major amendment coming in by way of 42nd Amendment, which inserted 2 more things into the preamble, which is essentially an indication of the social contract theory in India. So and again now there's a huge debate happening as to should we go back, should we especially in terms of secularism and all, should we go back or should we allow it to continue in our constitution? So this is absolutely, I think, in terms of democracy as well as in terms of secularism, I think it's going to be a huge debate that's happening in India. So thank you for pointing out, and that's a very valid point.
You are very welcome. It's a really pleasure. I'm very happy to see you because I follow you, and so I think this is an avenue and a path that we can work all together, and I think it can be really relevant on to at least to diagnose or to analyze from a different perspective what is happening from a political but also constitutional perspective in India, and you guys are the one to do this. For example, we can establish a kind of dialogue about which are, let's say, the basic principles of the Indian social contract. Who is with the people in the Indian constitutional sphere, right? Because we're talking about the most popular democracy in the world. So So these are different topics and issues that, with our experience in the EU social contract, can be then transplanted or not discussed, or not, again, the colonization, decolonization, what happened with India after the British mandate, with Pakistan also. I think it's also very relevant. What is the Pakistani-Indian relations, and how the social contract then was muted or not, so, and also Bangladesh, of course. So thank you very much, and we will stay in touch, definitely, and probably we will work together on this issue. Thank you very much.
Yeah, sure, Professor. Thank you.
I think it's time. Very welcome. If there's is there other questions? No, I don't see it. So I think now, if it's not, it's time to my friend and Professor Jakob HOLDERSTEIN, who is the work package leader on insecurity and expertise on philosophy of law and an expertise on Ukraine. So it's Jakob, Magatak. The floor is yours. I'm really eager to listen to you. Thank you very much, Magatak.
Thank you very much, Antoni, for this kind introduction and for being the PI of this very interesting and extremely important project. I will say a little bit. I will just see if I can share my slides. Do you see these slides now?
Yes.
Excellent.
Yes, perfect.
Okay. Thank you very much. As Antoni mentioned, the project as a whole investigates the social contract and the EU through a number of different prisms or perspectives, problems, and I will be talking about. I was sort of given the predefined task of investigating insecurity, and I was asked if we could look at insecurity either through COVID, pandemic, or the war in Ukraine were suggestions that Antoni mentioned. And the picture you see on your right-hand side is from the meeting we had when we discussed this possibility, and I pitched the original idea of this work package studying the war in Ukraine, or EU and the social contract, through the prism of the war in Ukraine. And I did this. This is a screenshot from the Zoom meeting we had when I was driving a car to Ukraine full of winter clothing for Ukrainian soldiers, and the car given to them to be used at the front. So there was a serious background to all of this, and there is a serious background even more so now. And that's the starting point of this. But I will say a few things about, in a way, it seems like a contradictory in adjecto or the antithesis of EU and the social contract to look to the war in Ukraine for an inroad to this problem. First of all, it seems like there is basically no EU there. Apparently, at least, Ukraine is not an EU member state, and EU is not a party to the Rome Statute, insofar as a war is and especially a war of aggression, as the one we are looking at in Ukraine, is one that renders topical and relevant and very acutely relevant international criminal law. And in particular, the International Criminal Court has been granted jurisdiction by Ukraine to look into the war and to see if there are, or to what extent there are, war crimes, crimes against humanity, and genocide taking place there. And the EU is sort of the odd one out here, because formally the EU does not play any role in the Rome Statute or in the ICC. It's the individual member states, of which, of course, there are many EU countries, but that's about it. So the EU seems to be absent, and also it seems, at least if we go back to the original Hobbesian sense, or well, we can wait a bit with this. There seems to be no social contract insofar as, and what we talk about as the social contract in an EU context. Then traditionally we see we see Ukraine and the old Eastern Bloc, and especially countries like Ukraine that were directly under Soviet rule as being sort of standing outside the social contract. We have a kind of European, intra-European Orientalism, and they are the Orientalist. They are those who belong to the Orient, those who are standing outside the ordered world as we know it, where a social contract rules. So in that sense, Ukraine is outside. And then specifically, the antithesis we see in the war in Ukraine after the outbreak of the war, both in 2014 and in particular the big war in 2022. With the Russian big-scale invasion, we had a full-scale war in Ukraine, and traditionally, going back to Hobbes in particular, then we have a state of nature. We have the exact antithesis of a social contract, and in Hobbes' theory, at least, social contract theory, a state of war is there's a binary there. A state of war is the exact opposite of a social contract. It's a situation where everyone has a right to everything, and that means no one has a right to anything. It's a state. It's a situation where life is poor, nasty, brutish, and above all short, as Hobbes famously put it. And even more so, it seems that even if it's not expressed in Hobbesian terms, the standard critique of the idea of international criminal justice is that basically the presumption or the foundational assumptions of criminal justice, of this idea of regulating behavior through the threat of punishment, is something that presupposes a notion of rational actors, of perpetrators or actors in a situation of criminal justice as being rational actors who are in principle capable of comprehending the idea of the threat of punishment and rationally thinking, even if they would like to perpetrate a particular crime, then the threat of punishment makes it suboptimal for them to pursue that path of action, because the punishment that will be inflicted upon them will outweigh the benefit that they will achieve by committing the crime. And the problem is that in a state of war, so the critique goes, there are no rational actors. Everyone is just living hand in mouth and fighting for themselves to survive for tomorrow. And also, furthermore, adding to this, there is no legitimate authority that can issue, that can claim, define what is right and what is wrong. So these are the sort of to raise the stakes to the highest possible level. We can say these are the reasons to think that any idea of a social contract and of EU being present in the war in Ukraine, in the state of insecurity in Ukraine, is severely challenged. And this sub-project, this work package, approaches this challenge with a kind of skepticism. It works from the assumption or wishes to investigate the hypothesis that in spite of all these sort of very good, strong reasons to consider this a place where all bets are off and there is no EU, there is no social contract, it's just every man for himself and a state of war and a state of nature, then the hypothesis is that below this, or imminent in that chaos and tragedy, we see a rudimentary presence both of the EU and of the social contract in the war in Ukraine. We see justice working as a regulative idea there, against all odds, it seems, in the working as a regulative idea in the Kantian sense. I will get back to this. And the method for investigating this is that we wish to move away from or beyond or qualify what in the Hobbesian tradition is a standard armchair philosophical approach where Hobbes was sitting in his office, in his chambers, and thinking about this, and conducted the thought experiment basically of imagining hypothetical situations of states of nature that he admitted had never really existed, that were more like a limiting concept of our minds, and contrasted this idea that he engaged in his imagination and developed as a counterpoint for society to develop his ideal social contract, which he also in a way considered to be imaginary, and then based his entire political philosophy on this armchair philosophical approach. Then we wish instead, and I'm doing this, sorry, it was on the first slide, and my colleague Nicholas Mogensen, who is joining me on this project and working with me. He's a sociologist of law, and I'm a philosopher of law. So we're trying to combine our efforts, and this means also not only that we move away from the armchair philosophy approach, but also away from, in a more legal doctrinal sense, we adopt or engage the notion of moving from what Eugen Ehrlich characterized as the traditional doctrinal legal approach to law, to social contract, to constitutional law, as an issue of law in the books, something that you would in Kelsen's and Ehrlich's Austrian-Hungarian Empire study in the empire's central city of Vienna, and there you could, using the doctrinal legal method, identify the law of the land in all parts of the empire. Ehrlich, as a sociologist, went to the most remote parts of the Austrian-Hungarian Empire. You see furthest to the right in this picture. He went to Bukovina, which is incidentally, or not incidentally, part of Ukraine of today, and there he studied instead what is the law according to which people actually live on the ground, what is, as he said, the living law, not the one that you identify using traditional doctrinal legal methods, but meeting people, talking to people, finding out what they actually are, what norms they are actually abiding by, and feeling it makes sense to live by. In this sense, that's the hypothesis that there are rudimentary or imminent EU and social contract in Ukraine, in the war in Ukraine. And in a way, we're not just trying to prove that it is there. It's rather a modal investigation. We are so more or less confident that it is there that we are investigating not whether or not it is there, but rather how it is there. How does EU and the social contract manifest itself or exist in the war in Ukraine, in spite of its sort of formal absence? So I will just give a very brief sort of overview of the signs we are identifying of this imminent or rudimentary presence of EU and of the social contract in the war in Ukraine. And starting with EU, it seems that EU, in spite of formally not really playing a role, it's informally or behind the scenes and politically playing a role in coordinating a lot of the efforts, both paying money to, investigating war crimes in particular in the war in Ukraine. It is working through activating, and we have been talking to a former member of Eurojust, which is an organization under EU which brings together in sort of an informal working network of investigators and state prosecutors from across the EU countries, and Eurojust is right now engaged also in helping very strongly, they are themselves conducting, but also coordinating and helping Ukrainian NGOs, among others, in conducting investigations, documenting war crimes in Ukraine. And this is where you see the picture in the bottom right-hand corner of Alexandra Matvichuk. She was just in Denmark, in Copenhagen, a few weeks ago, and I had the pleasure of organizing a seminar with researchers at the University of Copenhagen, but she was also at the parliament in Christiansborg in Copenhagen, meeting politicians. And she's the head of the Center for Civil Liberties, which was established in the 2000s in the North, and which has systematically been conducting investigations into and documenting war crimes in Ukraine since 2014, in particular the disappearance and enforced disappearances of Ukrainian children from occupied territories, but also war crimes broadly speaking. And Nicholas and I, we had the pleasure of conducting an interview also with Alexandra Matvichuk, and I should add, by the way, that her Center for Civil Liberties, together with two NGOs from Belarus and Russia, jointly received the Nobel Peace Prize in 2022. And she's an extremely interesting person, and she's working on this, and she told us about how, after working on this for several years, she sort of entered into a crisis or of despair, because she asked herself, why continue? Why a question of ambition? Why is she doing this? What does it all amount to, when it seems that Russia may be winning the war and that there is no road to actually achieving justice? So she's just documenting a lot of crimes, even though there will be no prosecutions, because basically the perpetrators will there will be no accountability. They will just travel home to Russia. And especially now, as in light of events over the last week, in particular, tragic events in the US entering the scene now, it seems that they might very well get away with it. And the question is then, why continue? And she described how she's been meeting also with a lot of these victims who have escaped Russian torture, imprisonment, relatives of victims killed, raped, etc., the most terrible crimes, objects to victims of the most terrible crimes, and they are she's meeting them, and they are saying that there is no hope, and they sound like they are in utter despair, and are just saying that there will be no accountability. And then she asks to them, and that's also what she says to herself. She says, but you are here now. And in a way, there is a performative inconsistency. They are verbally saying, this does not make sense. In a sense, this is a state of nature. There is no meaningful way in which we can be here and conduct this and achieve justice. Yet they show up, they find it meaningful to bring witness, to bring their testimony. There are other signs, and I'm showing this video of a Russian tank crew surrendering to a Ukrainian infantry platoon. There are signs of a rudimentary social contract in the midst of the war, in the midst of the state of nature that is the war. For instance, the then Defense Minister Reznikov gave a speech to the Ukrainian. Sorry, he precisely did not address Ukrainians in this speech. He gave a speech in Russian to the Russian military and political leaders, and also to the foot soldiers and the officers in between, saying there will be accountability. We will, now you have a choice. They were addressing them precisely like rational agents, what the critics of international criminal justice say that they will not be able to get, or addressing them as the kind of agents that the critics deny that we can have in a state of war. The I Want to Live project is a Ukrainian project that tries to sort of convince Russian soldiers to surrender to and give QR codes that they, as leaflets, they send into Russian occupied territory with QR codes where they can read how they should behave, like you see here, the Russian tank crew surrendering. And there are testimonies of generals in Moscow all of a sudden saying, well, perhaps we should adjust the way in which we conduct the war after the ICC issued arrest warrants. So here we see sort of rudiments of international criminal justice, of a social contract making some kind of sense. The idea of justice, truth, accountability, punishment, at least as a regulative idea. There is a hope, they show up, there is also a promise, and we talked with Alexandra about the ambiguities of perhaps issuing too strong promises to victims and relatives. There is a threat that has an impact on the behavior on the ground. There are tank crews that surrender, generals in Moscow that all of a sudden feel the heat and say, oh, might I end up in The Hague over this? It's a process. It's something that happens in the present. Alexandra spoke about how she's very aware of this as a moment where she can help shape international criminal justice as a dynamic phenomenon, but also something that is happening now, not only as something that we will deal with afterwards. It's something that we are dealing with now. And then finally, one way in which it is present, and I will more or less end on this note, I have a colleague, a Ukrainian colleague, an associate professor at the University of Copenhagen, Irina Marchuk, who helped co-organize this event with Alexandra Matvichuk. She is herself one of the leading international experts in international criminal justice, and she's, as I said, from Ukraine. And she spoke about how originally she experienced international criminal justice traveling to the West long before the war, thinking of international criminal justice as a Western invention. And then she has come across, and especially if any of you are familiar with, otherwise I warmly recommend this book by Philip Sands, showing how what we all consider to be the beginnings of international criminal justice today, the Nuremberg Tribunal, military tribunal, where the political and military leaders of the Nazi regime were tried and convicted, and many of them executed for their crimes. The legal framework was essentially shaped by Ukrainian Jewish refugees, by Herr Lauterpacht and by Lemkin, who both developed the fundamental legal concepts that we have used to conceptualize international criminal justice, to sort of build a structure, a legal infrastructure through which a grid through which we can look at and make sense of rights and obligations in a state of war, all of that which Hobbes claimed was not there. And this, which is now a European idea, being pursued in The Hague, in the heart of Europe, was originally a Ukrainian idea. So what we are now bringing to Ukraine is actually the ideas of genocide, the concept of genocide, which was Lemkin's idea, the concept of crimes against humanity, which was Herr Lauterpacht's idea. They are today shaping the contours of the ways in which all of these efforts are put into in a joint effort by Ukrainian national authorities, state authorities, in collaboration with the EU to enforce a kind of social contract. So that is kind of the outline of the project as we're seeing it right now, but we are looking more into, and we are seeking out more. We are going to Brussels together with the colleagues on the general EU Express project in March, and also we are hopefully going to interview more people from Ukraine about this. But to end on a question, and I will leave the floor to all of you guys, I think Alexandra Matvichuk's, because she suggested answers, but I clearly felt that she also felt the doubt still, and the questions of despair is, I think, a question to all of us, and a question also to you. Does it matter? Does it make sense to speak of justice, of some idea of a social contract? Can there be justice in an unjust peace, if that's where we are going right now, which looks very much like it? Or put differently, can we make sense of EU and the social contract in Ukraine? And I will end on this, and I will be very happy to have your questions, comments right now, and also in an email. Please feel free to contact me, and I will stop sharing here and give the floor to any questions that might.
Please, everybody, feel free to raise your hands. I will activate your microphones because right now you are not able to do so by yourself. So if you have any questions, you can also write them on the chat as well.
And also, if there was anything that was unclear, I mean, it was quite speedy traveling across a lot of different issues here. So please, if you would like for me to just elaborate on something.
Virginia, I don't know how to raise my hand in my mobile phone, so I raise it.
You can just jump in, Tony.
Please, Antoni.
Okay, sorry, I raised my real hand. Okay, so I have well, this is more a curiosity to Jakob. So, what do you think will be the role that the European Union need to play now in the Ukrainian Russian conflict or invasion or the genocide? I don't know which term you want me to use, but what the role that we Europeans and the EU, because it's not clear now, especially with what happened last week, right? And how the position of the United States seems to be more let's say, protagonist and trying to exclude apparently the EU. So I'm really, especially because in my understanding, one of the main reasons of the Russian aggression to Ukraine is because Ukraine wanted to be a part of the European Union, and because the Ukrainians adopted our values, their own values. Mm-hmm. So we are called to do something and to participate somehow, or to be included, in my understanding, on this process. Sam, thank you very much.
Yeah, these are excellent questions, and this is more than any of us would like, a moving target. And right now, these extreme changes are happening that are exactly putting EU, I would say, even more so at the center stage. Our main focus in this specific project, I mean, we have limited powers and manpower behind, is on the international criminal justice aspect. But and there EU is pushing a lot. But right now it seems that EU in some kind of mix with we see the ghost of the EU army being mentioned and is maybe entering the scene. So all of a sudden we see perhaps EU playing a more formal role also as a peacekeeping, or perhaps even more so as a warring party, and that will of course it's together with the UK, which no longer is in the in EU, but it does seem also that EU is thought of as an element here. However, at the same time, it probably does not evade anyone's attention that there are quite vast differences across the EU in how much this concerns the different member states, and you are sitting in the Iberian Peninsula, where my impression is that the burning platform feeling is not terribly strong, and we in Denmark, and especially we control the entry to the Baltic Sea, and we have Bornholm as sort of a very, very strategically important island in the middle of the Baltic Sea, together with Sweden, Scotland, and Gotland Island in the Baltic Sea, and then the Baltic countries, Finland, Poland, Ukraine, of course, and then Germany seems to be, and France are the countries that. So there is also this option that we will see a more fragmented picture, and I don't know what will happen. None of us do, of course, but it's a good question, and what role there will be for EU here. But I think it will be implicitly present insofar that we speak of EU as we see this as an ideological clash, and now unfortunately it seems to be falling together perfectly in inverted commas, that in fact the ideological alignment between the US and Russia is more or less perfect now. What Trump is trying to do is just normalize the kind of the war is a bit there. Putin went a bit overboard, and we wish to bring it back to something more open and feature-like. That seems to be so. In that sense, the perspective on Europe is one of a replacement struggle between the Democrats and the Republicans, where EU member states and the UK are the Democrats, who are politically correct woke liberals in the eyes of the US, whereas we just need to get Putin to stop the war, then bring it all back to and there is a perfect alignment there, where he invests himself with Van's meeting with Alternative für Deutschland and all of that. So the ideological clash is of course one with where the bloc that is coming together in Europe is one that overlaps ideologically with the EU. Yeah, I'm shooting in many directions, but I hope it makes some kind of sense. Cannot hear you now, sorry.
I was simply saying that it does, and thank you very much.
Thank you.
Okay, so I think there are no more questions, right? So I think we can follow with the program, and the floor will be now for Giuseppe Martinico. Again, thank you very much, Jakob, for very interesting presentation. And now is the time for Professor Martinico. Giuseppe,
thanks indeed, Antoni. Thanks for this invitation. Thanks to Jakob, of course, for his very fascinating presentation. I'll try to share my PowerPoint, but we had some issues. I mean, the last time I tried. So please let me know if you can see the presentation. I don't see you now at all. So please open your mic to confirm
we see it.
that.
We see
all right.
it.
We do it.
All right. Okay. So, can you also see when I move to the next slides, right? If I do
Yes.
this.
Yes,
All
we
right.
do.
Brilliant.
Yes.
Brilliant. Okay. Well, thanks indeed. And this is
But sorry,
the pleasure.
Giuseppe.
Yeah.
Giuseppe, right now it's not in the presentation mode, so we can see if you
I
have
know,
any
but
notes.
if I try to share in the presentation mode, like
Okay,
doing
no
this
worries.
way,
Just so you know.
can you see now the in full screen presentation mode? No,
No,
I don't think it's working. No,
it's fine.
I
No
don't think
worries.
All right, so then I'll go this way, okay? So if you don't see, I mean, the different slides, let me know, open your mic, and I'll try to fix it, okay? So, but in the meantime, let me start by saying that, let me also use my, here we go, in this session, we will try to see the relationship between populism and the EU social contract. Then I would like to start from some definitions, okay? This is probably the most famous and well-known definition of populism. It has been given by some eminent scholars, in particular Casmude, but also Cristobal Dovira, Carl Wester. They define in this quote populism as something that is dichotomous in nature, that employs and exploits to a certain extent the moral argument to present the superiority of the real people, seen as a sort of homogeneous entity, and that tend to divide the society into two camps, I would say. The real people, which is virtuous, which is characterized by a moral superiority, and the others. And the others are seen, according to this dichotomous approach, as the enemies of the people. So you can see here three elements. The dichotomous approach, the use of the moral argument, and the anti-elitist flavor of populism. Now, this is a definition which cannot grasp the complexity of populism, actually, because the populism presents itself in different forms. This is a definition that is very good if you want to understand right-wing forms of populism, but it does not work well when applied to left-wing forms of populism. That's why, according to Isaiah Teberlin, I don't know if you can see now the slide with a citation taken from Isaiah Teberlin. Once, when trying to define populism, he said, well, here we have a sort of Cinderella complex. I mean, we can come up with beautiful definitions, the show, according to this parallel it trying to draw, but then there will be always right, I mean, feats phenomena that cannot be traced back to the theoretical definition we have in mind. That's why it's very difficult to define a priori what populism is, as there are different forms of populisms in the plural. Okay, so now the important thing to understand my approach is, how should we conceive populism? And I think that populism, of course, can have negative effects over the constitutional system of a country, but it shouldn't be understood only as a pejorative phenomenon. Okay, in this sense, I think that, and this is also the way in which we understand it in the project, populism should be seen as the shadow of democracy. So it is a phenomenon which is always present in the life of the constitutional democracies. We perceive it that as a problematic when democracy actually suffers from a broader crisis. So populism is not the main cause of the crisis of liberal democracy and liberal constitutionalism. Populism is instead the symptom of a broader crisis. And another important caveat that I want to make before going to the juicy part of the session is the following. According to scholars, there are two views on the origins of populism. According to some economists, for instance, President Roderick, populism mainly has, some would say, economic causes. So it's the outcome, it's the reaction, it's the consequence of, for instance, a season of financial and economic crisis. I mean, think of what happened in Europe after the austerity policies deployed by the EU in order to deal with the financial crisis, with rounds of and new waves of populism emerged throughout the continent. Now, according to other scholars, and I'm very sympathetic, I think that they are right, it is that populism shouldn't be seen only as the reaction to the economic crisis. That the populism is a broader phenomenon. It is a form of cultural backlash. Okay, this is what Pippa Norris and Engelhardt argued in this important book, Cultural Backlash. And this is how I understand populism. Now, let's move to the definition of the second keyword. Can you confirm that? Did you see the slide with the definition of disruption now? Can you open your mic to confirm that, please? Hello?
Yes.
I need your confirmation.
Yes, Giuseppe.
Thank you. Okay, so disruption is the second keyword to present in the title of our talk. Well, disruption shouldn't be understood as a fungible concept of distraction. Disruption and distraction are different concepts. The disruption refers to the interruption, to the significant change of an existing system, but it does not necessarily imply the break of the system. Okay, so this means that populism, seen as a disruptive element of the social contract, shouldn't be seen as the end of the social contract. Populism will, of course, it has a huge impact over the current architecture of the European Union system and over the architecture of the constitutional systems of its member state, but it does not necessarily mean the end of the social contract. This is the perspective I want to adopt when looking at the impact of populism over the EU social contract. In other words, populism should be seen also as a window of opportunity, which allows us to reinvent or to reinforce our systems of the constitutional democracy, provided that, and this is a crucial premise, provided that we don't abandon the counted majoritarian flavor of constitutionalism, which is an important component of the concept of constitutional democracy, as we will see. Okay, so in this sense, populism can be seen as an opportunity to rethink the constitutional system, not only as the end of the social contract. Okay, so clarify that. I think it's possible to study populism from a constitutional law viewpoint. I mean, normally the debate on populism has been monopolized by the political scientists, by historians and sociologists, and they have done a pretty good job. Okay, make no mistake. But I'm saying that it's also possible to understand, to study the populism from a constitutional law perspective. After all, as we will see, populisms in the plural inevitably oblige us, I mean, to deal with some long-standing questions in constitutional theory. For instance, the relationship between representatives and democracy, the issue of the neutrality of constitutions. Can constitutions be neutral, and how? And the issue of the limits to constitutional amendments. Indeed, many of the constitutional law scholars originally have approached the relationship between populism and constitutionalism, limiting themselves to the very important issue of the unconstitutional constitutional law amendments, for instance. Okay, I know that our Indian participants are very familiar with this scholarship and with the idea, of course, of the basic structure doctrine. Okay, but I think it's also possible to go beyond them in that. I think that populists, when they are in power, they of course, try to amend the constitution. Also, they try to sometimes, put in question the untouchable core of constitutions, but more generally, I think that they try to approach the constitution in a more subtle manner. So, trying to, first of all, trying to create a constitutional counter-narrative. So, trying to favor a manipulative and abusive interpretation of constitutional concepts. And this is what we are gonna do in the last part of this session. And indeed, my research just tried to focus on how populists in power use categories of constitutional theory. Think of the way in which they use the concept of democracy. Think of the way in which they use the concept of popular sovereignty, that of constituent power. They also tend to use in a cherry-picking manner instruments of constitutional law. Think of the way in which they try to destroy institutions of representative democracy by relying on the referendums, for instance. So, in our research, instead of defining what populism is, we saw in the first slide, how difficult this exercise is. We instead try to analyze some intimations of populism, some intimations that are particularly interesting to constitutional law scholars. And these three intimations or these three ingredients of populism that are particularly interesting to us are the following: extreme or radical majoritarianism, identity politics, and what Luigi Correa has called the politics of immediacy. What are they? So first of all, I'm going to describe these three elements, and then I'll try to show you their impact over the usual understanding of the constitutional democracy. Let's start with extreme majoritarianism. Extreme majoritarianism refers to how populists understand constitutions and social contracts in general. They understand the Constitution as straitjackets and obstacles to the fulfillment of the will of the people, their real democracy. Indeed, populists tend to reduce democracy to the mere rule of majority, and this is, of course, at odds with the counter to majoritarian nature of constitutionalism. What do I mean by counter to majoritarian nature? I referred to the role of supreme or constitutional courts that are there to declare the invalidity of those laws passed by the contingent majority when these laws affect the pluralism, when they affect the rights of minorities. So, while the populists have an hyper-majoritarian understanding of democracy is the mere rule of majority, the supporters of the constitutionalism instead stress the importance of pluralism and the importance of the protection of minorities in a democracy. Okay, that's why populists try to construct again the dichotomous approach, a false dichotomy when dealing with the constraints stemming from constitution. Populists frequently argue that democracy and constitutionalism are antithetical concepts. Okay, this is, of course, at odds with the very idea of the constitutionalism we have, especially in Europe. Don't forget that in the European continent, many constitutions have been written after the end of World War II, and in many constitutions you have clauses that are there to protect some parts of the constitution that may not be amended in order to impede the return to the past, right? So, I mean, European constitutions are characterized by a lot of counter to majoritarian instruments that are codified there. Okay, so first element. Second element, identity politics. Identity politics refers to how populist powers depict the identity of the constitutional subject and of the popular subject, so the people. Okay, the people here is represented by populists as characterized by a certain dose of homogeneity, by the sharing of the same values. So values here are seen as pre-existing to the actual moment of writing of the Constitution. Constitutions are seen as documents aiming at securing identity, and identity is understood as sameness, so as something that does not evolve. Okay, so according to this idea, constitutions for populists should codify only those values that belong to the majority. As I told you, for populists, the people is actually the majority. The minorities that don't share the same values of the majority are seen as the enemies of the people. This kind of dynamics, when codified in the constitutions, has led to the progressive discrimination of some parts of the constitution. Think of what you can see in these slides. Okay, so I have reproduced here two articles of the Hungarian Basic Law and of the Russian Constitution. In Hungary, they codify this concept according to which the protection of the constitutional identity and the Christian culture of Hungary should be an obligation of every organ of the state. This provision has been used to discriminate those portions of the Hungarian population that don't share, that don't have as their religion the main Christian one. Okay, and you can see here the instrument of the conservative argument. The argument of tradition is used together with the religious argument and the historical argument to actually identify two factions in the population: the real people characterized by this homogeneous identity and the others. And this has led to what Antal called the constitutional image of enemy, and to the weaponization of constitutions. So the constitutions are not there to protect minorities and to pursue the pluralism. The constitutions are there to codify the superiority of the majority and of its values over the minorities. Identity has also been used by the Constitutional Court of Hungary, for instance, as a shield to justify the non-compliance with the values of the European Union. So here, identity politics is used to actually destroy the EU social contract in a manner, or to at least, question it radically. This is a passage taken from a very important judgment given in 2016 in the field of asylum seekers, in which the Hungarian Constitutional Court that has been captured by the contingent majority has used the concept of national identity, as if it were a wall that distinguishes the real people from the others, from the enemies, to actually question the supranational obligations. Finally, politics of immediacy. Politics of immediacy refers to the fact that, according to populists, there is a sort of direct relationship between the leader and the people. So this kind of idea rejects the concept of mediation offered by the representative institutions. Actually, parliaments, institutions in general, the political parties are perceived by populists as a factors of fragmentation. If there are some homogeneous values that should be preserved, all the factors of pluralism are perceived as an obstacle. Okay, that's why populists like the referendum and all the instruments of direct democracy that are frequently employed to question the centrality of parliaments. Okay, this is exactly what Luigi Correas calls politics of immediacy. So by relying on this free concept, extreme majoritarianism, identity politics, and politics of immediacy, populists frequently questions what actually comparative law shows. So the comparative law shows that democracy is a complex concept. They instead approach it in a very deductivist manner, deducing it to the rule of majority. The comparative law shows that it is possible to use the referendums in constitutional democracy, but they should be made compatible with the activity of the parliament. Comparative law also shows that the chains of the constitutionalism have a democratic function. They serve to preserve minorities and pluralism. And this is a confirmation of that, I mean, taken from the case law of the Canadian Supreme Court, I mean, which said once that democracy means more than the simple majority rule. So, I mean, while populists tend to use democracy as a trump card which should prevail always over the other stars in the constitutional constellation, so constitutionalism, the rule of law and protection of minorities, populists instead, their constitutional counter-narrative use democracy as a trump card. But why we should reject an idea according to which the democracy is only the majority rule? Because majorities are the political construction. This is what, again, the history of comparative law, I mean, shows. I mean, think of the manner in which the majority can be constructed by including or excluding portions of the population from the right to vote. Okay, what should we do? The last slide. I think that the constitutional law scholars make a mistake when they claim to protect the constitutional democracies by defending the status quo. I don't think this is the solution. I think I said that we are witnessing a broader crisis of the constitutional democracy as we know it, and this, instead of actually adopting a conservative approach, we should try to, I mean, use this crisis as a window of opportunities. We should try to reinvent our democracy in order to reinforce it. How can we do that? And this is for the Q&A session. If you wanna also, I mean, bring your knowledge to the comparative table. So the questions are, can we exploit some of the claims made by populists to improve democracy? My answer that will be yes, but only if the core of constitutionalism is preserved. So how can the referendum be made less primitive and binary? Should we abandon the concept of identity? Should we rethink the role of constitutional courts? These are the real questions that the populism, I would say, brings to the political agenda of the constitutional democracy. The comparative law offers the different solutions, but I will be curious to explore them with you in the Q&A session. Thanks so much for your attention. Are you still there?
Yes, we are here. Yes, we are. I want, you know, I will have a mobile phone, so I wanted to also clap my hands, but I don't find it in my mobile phone. Okay, so is there any question, Virginia? Do you find someone with questions?
I don't see any hand raised so far.
Okay, so I mean,
yes,
there is someone.
Wait a second.
Should we gather all the questions in order to have a final round of answers?
Maybe, yes, of course.
Yeah, please. Szilesi, we cannot hear you.
Szilesi, you can now activate your microphone. Or your camera as well.
Yeah, Szilesi Waleling. Maybe your pronunciation is not correct, Giuseppe, and that's why.
Ah, that's why. Please open your mic and share your thoughts. I think it's not working. If you want to write your question in the chat, I'm also happy to respond to the written version of your question. Any other questions or also doubts? So if I was not clear, please let me know.
I don't know if there are other questions. Otherwise, I can jump in again. Sorry, I don't want to be protagonist, but I would like to ask you something, Giuseppe. So
please.
It is conceivable to think. It is conceivable after seeing your framework, your studies on the populism. I think now it's working, or someone, I don't know.
Yes, Szilesi,
yeah, go ahead.
Sorry, thank you for interruption. Okay, it is a very contemporary issue, especially in African continent. This populism is, I think, we can call it a threat to a constitutional order or democratic order, because these populist governments may use this populism to build new constitutional order or new constitutional system. So is that possible to conclude that it is a threat to democratic system or constitutionalism?
Thank you.
Okay, thank you.
Thank you. Antoni, it's your turn now. In the meantime, don't be shy.
Thank you. So my question was, well, I don't know if it's yes, I think it's a question and not a comment. So it is, if you see, for example, and because we have a lot of Indian students today, there are some accusations of Modi to be a populist in some of the policies and that he's implementing. My question is, there are two questions. The first one will be, it is inexorable, is inevitable that some of the policies are somehow related with populism, meaning all the political parties in all the different spectrums, there are somehow in the policies that they are practicing, in the aspirations that they are proposing, is inevitable, is something that we cannot avoid, unavoidable, right?
Yeah.
And the second question would be, it is possible, because this is something that I listened lately, it is possible to see that there is also a populist discourse and narrative of the European Union against the states. Thank you very much.
Thank you. Any other questions or comments? Or also personal offenses, if you want to blame me. All right. So I think that could start, and then I will. Concerning the first question, is populism a threat to constitutional democracy? Well, in a way, if it is not tackled, I think with the right strategy, it could become a threat. That's why. As it happened in Hungary and to a certain extent also in Poland, populism has created actually a form of deviation from the democratic values, and it has become a form of illiberal or even authoritarian populism. But my point is that populism does not necessarily lead to this kind of outcome. So especially if it is contained in the right manner, and it also depends on the constitutional design of the country at stake. I mean, and then I compare the constitutional lawyers. I always try to contextualize the issue. For instance, in Hungary, probably populism has made, this authoritarian deviation possible because of the way in which the Hungarian Basic Law was written. I mean, they have no alternative clause, which means that the contingent majority can change all the fundamental parts of the constitution by the majority. This can be also explained the fact that Hungary is not a federal system or a regional system, and that the federalism can work as a device to guarantee checks and balances, especially against authoritarian trends, as it partially happened with the first Trump presidency. Now we will see what is going to happen in the future in the United States. So, I mean, the constitutional design is very important. And if the constitutional design is robust, then populism can be contained. But also, we should try to, again, find the counter-argument to question the way in which they manipulate categories and instruments of the constitutional law. So if, for instance, instead of blaming referendums because they are so primitive and binary, we should perhaps try to adapt referendums, to the current functioning of constitutional democracy. How? By, for instance, having multi-stage referendums, as it happened in New Zealand with the referendum on the flag, or by having different rounds of referendum, as it happened in New Caledonia. So there are instruments that can be used to, in a way, mitigate the anti-parliamentary flavor of the referendum, and in order to question the monopoly that populists claim to have on the instrument. This is just an example. Concerning the second question, second and third question by Antoni, well, I think that there are, I'm aware of the literature concerning the currently situation in India. Probably our Indian students know the situation, but in my view, it is possible to find some populist dynamics there. But I'm curious to know what they think. Can think, for instance, of the instrumentalization of the religious argument that Modi has used, to in a way present the identity of the Indian people as homogeneous. So, I mean, there's a lot of identity politics there. And concerning the third question about the counter-narrative, the narrative of the European Union advanced by populists. Yes, for instance, the populists are very good at presenting themselves as true Europeans. They say that they are not against the EU as such. They are against this kind of European Union, which is too much supranational. So what they advocate is actually a return to a sort of true intergovernmental, even more intergovernmental than it currently is. And this is the true Europe that they frequently take into account when attacking the European Union. So, of course, what they are trying to do is trying to destroy the European Union from inside, not from within. And so, I mean, but it is true that they are trying to present themselves as a true European, in order to actually control the system and to reform the system from within. Thank you. I also see another question there, Aina, if my pronunciation is correct.
Yes,
otherwise, apologies. Please go ahead.
Hi. Thank you, Professor. I have two questions. You define the populism through the sameness, often marginalizing minorities. So my question is, if the measures of the EU, there are effectivity to respond this marginalizing, like funding conditions or legal action, if there are effectivity and later I have another question. If how could the social contract be reimagined to counter the exclusionary populism especially in the context where it's already entrenched.
Thank you.
Thank you.
Thank you. Okay, so you're right. I mean, one of the reasons why, according to many scholars, populism and constitutionalism are in conflict is indeed the exclusionary approach that populists advance when reading the social contract. No, I mean, they claim that there are some fundamental values that should belong to the real people, and those who don't share, I mean, these values are seen as enemies, while constitutionalism is all about integration. So it's all about including, I mean, the others, even those who didn't have a role in the actual writing of the constitutional pact can be included if they follow the procedures, I mean, provided for in the Constitution. So while populism is exclusionary, constitutionalism is inclusive. How can we avoid the complete exclusionary understanding of democracy? Well, in my view here, the constitutional design is very important. And we should accept that there are devices, counter-majoritarian devices, then must have a role in our democracies. I mean, they are not anti-democratic. I mean, frequently populists depict courts or clauses providing for supermajorities in constitutions as anti-democratic instrument. I think that this is really a cherry-picking understanding of what the democracy is. If the democracy, as Hans Kelsen said, is also a place where in order to have a majority, we must represent minorities, then in a democracy, we should have devices aimed at limiting the power of a contingent majority. And this is, after all, what constitutionalism does. So the first, let's say, elements, good elements, I mean, to contain an exclusionary understanding of the democracy is including a huge dose, in my view, of counter-majoritarian instruments in the constitutional design. This will contain a lot, I guess. Of course, I'm not saying that the constitutional law can solve all the issues. I mean, courts, if they are not supported by the civil society, will fail in the long run. And this is what happened in Hungary and in Turkey to a certain extent. But I think that the constitutional design matters, and the constitution is the place where you can find the first ingredients against populism in this sense. The second element, how can we preserve the EU social contract against the populism? Well, first of all, I think that we should accept that the values enshrined in Article 2 of the Treaty of the European Union are not merely guidelines. This point has been defended by the Court of Justice of the European Union, for instance, against the constitutional counter-narratives advanced by Hungary and Poland. States that have argued that values are ethical guidelines. They are not binding norms. Actually, the first point to preserve the EU social contract is that actually having a consensus about the centrality of and the binding nature of these values. If we start from those values, I think that we can find actually different institutional forms that could make the EU more adaptive. Adaptiveness here is the most evident problem that the EU is currently having, in my view. But this can be fixed only if we accept, however, the centrality of the values of Article 2. Thank you. I also see another question that I don't know if we still have time. Can we have another question to Virginia?
I think that we can have a final one if Antoni is okay with that.
Please, thank you.
Yes, thank you, Professor Antoni, and thank you, Professor Giuseppe, for your insights on populism. You just answered that depends how the courts react when this populism is going on between in the nations, different nations. So my question I have observed here in India is that during populism and during some of the policies which were reflected by the present Prime Minister. So during this mean course, they try to hijack the court by bringing their people in the judiciary itself. So if they are for a longer run, because what happens in India in the appointment of judges of the high courts and the Supreme Courts, that the Chief Justice of India, through a collegium system, recommends the judges. And what happened during this time period, because it has to get the approval from the Prime Minister. So this body of ministers, they refuse to accept those recommendations or those judges whom they think they do not fit in their ideology and their principles or the principles of populism. So those recommendations which are given by the present Chief Justice of India, they were not accepted. And this is how, if they stay for a longer period of time, they will hijack the judiciary as well, which is able to, in some of the cases, protect some human rights of the citizen when the majority or when the liberties of some sect of people which are in minority, the court may use the principles of constitutionality and turn down certain legislations which violates the liberty of individuals. So just a suggestion, I would say that if populism exists for a long time, it will hijack every institution, and then for the people in minority, it will be like a nightmare.
Thank you. You're right. They very frequently populists target courts, and they try to change the composition of courts, and they're trying to change the appointment, the procedure, and they operating what we call the court packing, right? It is a very well-known phenomenon happening also in constitutional democracies. What can we do, I mean, to limit this? I would say three things. First of all, when writing a constitution, we should try to secure, in a way, the procedure concerning the appointment and the procedure concerning the functioning of these courts by relying on constitutional sources. So, I mean, on sources that can be amended only by a special majority. First point. Second element, I think that we should, and there are a lot of guidelines, I mean, given by the Venice Commission, a body of the Council of Europe, which has dealt with this kind of phenomena a lot. We should avoid that the contingent majority can appoint the vice president and the president of courts. I mean, if courts are capable of electing their president and vice president, they are, at least in the short run, much more autonomous. Third strategy, probably if courts are captured by the contingent majority, this means that they are not perceived by the civil society as useful. And this means that we have a distance here, and this means that courts are not capable of delivering, of explaining what they do, their democratic function. Okay, this means that courts should actually try to explain their function in a bit manner. There are many constitutional courts in Europe, even supranational courts, that have tried to use, I mean, social media platforms in order to contain, in order to explain what they do, in order to resist, you know, the attack of populists. I think that these three series of strategies are good, I mean, to at least to contain the risk of a capture. Of course, as said, the constitutional law cannot do anything. I mean, it cannot do solely, cannot do everything. So this means that if there are no robust institutions, such as, I mean, courts will fail in the long run, but we can mitigate, I mean, this risk, I think, by relying on these strategies. Thanks so much.
Well,
Okay, I'm done.
I think yes. I think it's time now to end with the first session. I really appreciate. Thank you very much, Giuseppe, for this very interesting presentation. Thank you very much.
And keep in touch. If you want to write me, you have my email and the PowerPoint. Thank you so much.
Thank you, Virginia. We can then share, I don't know whether in the website, PowerPoints, I don't know how these things we can do it in order that the students and the participants that they are interested in the presentations, that they may have the possibility to contact us and so on. So, well, with no more delay, I will closure now the first session. Thank you to all the participants. It has been very, very interesting. And see you tomorrow at 10. Again, thank you very much for this very pleasant journey. Thank you very much.